Hello, welcome to ethBeats. I'm Elaine Bay. Today I'm joined by Nandakumar and Gordon Nardell. Let me just do a quick introduction. Gordon specializes in international litigation and arbitration, practicing at 20 Essex in London and Singapore. He focuses on claims involving state bodies, combining commercial expertise with a sound understanding of administrative, EU, and public international law. For more information on Gordon, please refer to the notes to this podcast. Nandakumar is head of RHTLaw's Litigation and Dispute Resolution practice. Today, let's take a look at risks run by arbitrators who accept appointments in high-stake cases, especially with a politicized background. In January this year, a Spanish court jailed an arbitrator for contempt of court. What went wrong?
Well, thanks so much. Bear with me while I set the scene for the events that led up to this rather unusual event of an arbitrator being jailed by a criminal court. The Sulu arbitration against Malaysia has all the ingredients for potential ethical problems. It's a highly politicized case, as you say. It's a case with a very long history, and it's a very high stakes case. The Sulu arbitration begins with an 1878 colonial era agreement between the Sultan of Sulu and two European entrepreneurs. The Sultan of Sulu was the titular head of a territory forming now what's part of the modern Malaysian state of Sabah and the modern Philippines. It was an agreement under which the Sultan of Sulu ceded the right to commercially exploit his territory to the two European adventurers in return for a rent of 5,300 ringgit a year. And it contained a dispute resolution clause which required that any disagreement be brought for the consideration and decision of Her Majesty's Consul General in Borneo. So there was a dispute resolution clause under the agreement. When the interests of the former Sultan and the former adventurers merged in the modern Malaysian state on independence in 1957, Malaysia continued paying the 5,300 ringgit a year rent, and it continued until 2013. The reason why it stopped, and this is another of those red flag issues in these high stakes cases, was because there had in fact been a long simmering, semi-dormant territorial dispute between the Philippines and Malaysia over the territory of Sabah. And there was an armed incursion by Filipino nationals into the territory of Sabah. That was in 2013. The Malaysian government then stopped making payments. That prompted the individual heirs of the Sultan of Sulu, who are individual Filipino nationals, to attempt to bring proceedings against the Malaysian state. And they started by asking the British government to appoint someone to exercise the functions of the now defunct role of the Consul General in Borneo. The British government refused. And so what the heirs then did is that with the backing of a litigation funder, which is another red flag for ethical issues in arbitration, they commenced arbitral proceedings in 2017. They persuaded the High Court in Madrid to appoint an arbitrator, which it did, and it appointed as arbitrator a well-known Spanish arbitrator called Dr. Gonzalo Stamper. And Dr. Stamper proceeded with the arbitration. The Malaysian government was adamant that the original 1878 agreement contained no arbitration clause. It refused to recognize the arbitration as legitimate, so it didn't participate, and therefore the arbitration proceeded with only one active party, yet another red flag for arbitral ethics. The arbitrator, Dr. Stamper, made a preliminary award. He determined a Spanish seat for the arbitration, and he accepted that he had jurisdiction. In other words, he agreed with the Spanish court that the 1878 agreement contained an arbitration clause. What then happened, however, and this is where the difficulty starts, is that the Malaysian state applied to the Spanish court to set aside the original order appointing an arbitrator on the basis that the rules under Spanish law about service on sovereign states hadn't been observed. The Spanish court agreed, and it set aside its original order. So we're back to square one. It's as if no arbitrator had been appointed. What Dr. Stamper should have done in that situation is observe the court's direction, accept that his authority as an arbitrator had been terminated, The Spanish court also, through its clerk, wrote to Dr. Stamper, ordering him to terminate the proceedings. He didn't. What he did, in fact, was accept an application from the claimants to move the seat of the arbitration to France in order to sidestep the effect of the ruling of the Spanish court. So in France, Dr. Stamper purported to continue the arbitration until in 2022 he made a final award ordering the Malaysian state to pay just under $15 billion, not a sum to be sniffed at, to the heirs of the Sultan of Sulu. There are various proceedings in the French courts to set aside the preliminary award and the final award, and meanwhile attempts by the heirs to enforce the final award in the courts of various European countries have so far come to nothing. And then, as you say, we scroll forward to January 2024, when on a criminal complaint by Malaysia, a Spanish court has convicted Dr. Stamper for contempt of court for unqualified acting in office, because the Spanish court had removed his authority as an arbitrator. It decided that was conduct unbecoming a lawyer. It imposed a prison sentence of 6 months. It also disqualified him from acting as an arbitrator for a year. So a whole host of problems for the arbitrator himself, and a whole host of red flags that require an arbitrator to think very carefully about the ethical standards to be observed in a case like that.
So when Dr. Stamper moved to the French jurisdiction, what was that? Was that a surprising move, at least from a third party's perspective?
That was a surprising move. There are circumstances in which it's accepted as a general principle of arbitral practice that an arbitral tribunal can move the seat of an arbitration if the authorities at the seat are making it impossible or unduly difficult for the arbitral proceedings to continue, and it's necessary for the arbitrator to move the seat in order to preserve the integrity of the proceedings. Now, the learning, such learning as there is on this question, suggests that that discretion to move the seat only arises where the authorities at the seat are behaving in a way that's inimical to the rule of law. It's really egregious, deliberate, unlawful interference in the arbitral process. The best known example of that is an Indonesian arbitration called the Himperna case, where the authorities abducted an arbitrator. We're really talking about quite extreme behavior by the authorities of the state on a spectrum. That wasn't this case, and I think there's a general consensus that Dr. Stamper overstepped the mark. And what he ought to have done is observe the order of the Spanish court, requiring him to terminate the proceedings, await a fresh appointment, which might have been Dr. Stamper, might have been another arbitrator, but to bide his time and observe the ruling of the court. Generally speaking, an arbitrator, like anyone else subject to the jurisdiction of a court, will be well advised to comply with its orders rather than attempt to sidestep them.
So in your view, did Dr. Stamper do anything else that made himself an easy target?
This is where things get a bit difficult because, as I say, this case had all the red flags of potential ethical difficulties. It was a high-value case, a case with an undercurrent of political tension between the Malaysian state and the state of nationality of the claimants. And it was also a case in which one party declined to participate. So these were real difficulties facing an arbitrator and creating something of an ethical dilemma. Now, there are well understood techniques for arbitrators to deal with problems of that sort. So let's take perhaps the most obvious problem, which is a non-participating respondent. I myself sit as arbitration. I've been confronted with this problem. By and large, the duty of an arbitrator is to render an enforceable award. We all know that one of the grounds on which a party who hasn't participated in an arbitration, against whom an award is made, will attempt to set aside that award, is that it didn't have a proper opportunity for its arguments to be heard, and the arbitrator demonstrated bias by only listening to the arguments of the active party. Now, in that situation, it's incumbent on the arbitrator, in order to render an enforceable award, to go out of his or her way to demonstrate that he or she has not simply rubber-stamped the arguments of the active party, but critically evaluated them, looked carefully at whether the active party has established its case on the facts and on the law, considered what arguments might reasonably have been taken by the non-participating party had it participated, and really demonstrate throughout the award an even-handedness and objectivity. Now, it's fair to say that that is not what Dr. Stamper did in his award. Having looked at his award, it reads, I'm afraid, as a very one-sided exercise, an uncritical acceptance of the majority of arguments of the claimants, and some really quite piqued and almost personally offended language towards the conduct of the Malaysian state. I think it's particularly important that arbitrators, faced with the difficulty of a non-participating respondent, particularly in a case that itself has difficulty and sensitivity as part of its context, it really is incumbent on that arbitrator to go out of his or her way to demonstrate objectivity and a willingness to consider arguments that could have been taken by the non-participating respondent. And that didn't happen in this case.
I wanted to move on to discuss the ethics in situations like this. And I was going to ask Nanda whether you had any, or perhaps to kickstart the conversation around ethics in this space.
Well, one of the most important aspects of arbitration is the right to be heard in respect of both parties. Perhaps, Gordon, you could share with us your views on to what extent the arbitrators are required to ensure this right to be heard is part of the arbitral process which they are conducting.
It's fair to say that in most run-of-the-mill commercial arbitrations, this isn't a problem. Both parties actively participate. Both parties are represented by competent lawyers. Problems start creeping in when that last condition isn't met. So sometimes a party will turn up with no representation at all. That's unusual. A more frequently encountered problem is that the arbitrator realizes quite quickly that the legal representatives of one of the parties are unfamiliar with the arbitral process, or for whatever other reason, not quite doing justice to the presentation of that party's case. And that raises the interesting question, how far does the arbitrator owe a positive duty to intervene and assist the parties? And that can be difficult, but I think what the arbitrator has to do is exercise some judgment, think about what's required. The arbitrator should never descend into the arena and take a party's case, but an arbitrator might, for example, after the end of the examination of a witness by the party calling that witness, think about whether any clarification needs to be given in the case of an unrepresented party. If cross-examination is attempted by the other party's representatives and it doesn't really elicit what the arbitrator needs to know, then again it's perfectly reasonable for the arbitrator to seek to clarify, ask questions. What the arbitrator should never do is cross-examine, as it were, and behave as the advocate for the underrepresented or the unrepresented or even non-participating party. But that gives you a clue to how an arbitrator faced with a non-participating respondent should also act. Having heard a witness, the arbitrator is not obliged, and indeed may be bound not to simply uncritically accept everything that witness has said, but may be bound to probe, to clarify, to question, just to be satisfied that what the witness has to say properly establishes the case being advanced by the party calling him or her.
Of course, the arbitrator also owes a duty to the parties to be seen to be neutral as far as the arbitration is concerned. So to what extent does the arbitrator have to go to demonstrate that he is neutral?
Again, in most cases, it isn't a problem because both parties turn up. There's a rough equality of arms between the parties. But even then, arbitrators have to take care. Expressing a concluded view on an issue before the appropriate time for expressing that view has arrived, that's a bit of a red flag.
Yes.
So, for example, taking preliminary decisions dealing with substantive issues in procedural orders, which presuppose a particular answer to the substantive issues in the case, that's the sort of thing over which great care has to be taken.
Were there any other sort of interesting bits to draw or learn from this situation, from this case that you are studying?
Well, I wonder if I might deal with where we started, which is the prison sentence pronounced against this arbitrator. Now, on one view, an arbitrator is no different position to anyone else subject to the jurisdiction of a court. Anyone against whom a court makes an order who disobeys the order is at risk of punitive measures for contempt of court or similar. But I have to say, within the arbitral community, there's been a great deal of discomfort about this case, because the other countervailing feature about the position of an arbitrator is that arbitrators are generally entitled to immunity from suit and indeed immunity from prosecution in the ordinary exercise of their functions. Now, there are a number of complicating factors in this case. The most fundamental is that here the Spanish court had decided that Dr. Stamper's functions were at an end at the point when the court reversed its original order, appointing him as arbitrator. So his authority as an arbitrator was at an end. He wasn't an arbitrator at all, in other words, when he took the steps that got him into deep water with the authorities. But leaving that aside, it seems to me that as an arbitrator myself, I and indeed other members of the arbitral community who I've spoken to about the case feel rather uncomfortable about criminal proceedings against arbitrators. One factor in this case that may be problematic is that the Spanish court directed its order at the arbitrator himself, directing Dr. Stamper to end the proceedings. Usually, if a court wants to intervene in proceedings and arbitral proceedings and prevent them from taking place, this happens all the time. Anti-arbitration injunctions are not unusual, particularly in the common law world. What the court should generally do is direct its order at the parties, not at the arbitrator. And so it's unusual for the court to direct its ire at the arbitrator. But, and this goes back to the question you asked, was there anything Dr. Stamper might have done in this case to make himself a bit of a soft target? And I'm afraid that alongside the arbitrator's duty to render an enforceable award, to act impartially and be seen to be act impartially, I think commentators are clear that there's also a duty in an arbitrator themselves to investigate red flags and areas of concern. Now, we're about to get into a territory where I do want to make clear to listeners that while there have been various suggestions about the good faith, the legitimacy and so on of these claimants, I'm not casting any aspersions at the claimants or their funder or their representatives, but there have been suggestions. It's been put in various ways, and commentators have said, well, there are indications this was a sham arbitration or a fraudulent arbitration. I'm not in a position to make any comments on those suggestions. But an arbitrator faced with an arbitration, knowing that there is criticism about the legitimacy of the process, has to accept that as a red flag, which he or she is duty-bound themselves to investigate and take cognizance of. And the difficulty in this case was that through his conduct, through accepting rather uncritically the claimant's arguments, moving the seat of the arbitration to sidestep the intervention of the Spanish court and so on, what this arbitrator was unfortunately seen to be doing, perhaps by the Malaysian state and the Spanish authorities, was really not investigating red flags, creating red flags of his own, and therefore rather attracting the attention of the prosecuting authorities. So as an arbitrator, you're entitled to be robust, but what you must never do is fall below the standards of demonstrable objectivity, critical assessment of the arguments of an active party in the face of non-participation by the other party. Because however problematic it is for there to be a criminal investigation and criminal proceedings against an arbitrator, it does make sense for you to protect yourself in that situation by taking the rudimentary steps of discharging your ethical duties, not putting up your own flags, investigating yourself such red flags as there are in the case. And this is perhaps an object lesson to arbitral tribunals dealing with controversial and sensitive cases.
Yes, absolutely. Talking about funding and ethics, Nanda, do you have any comments from what you've seen in your own practice?
In terms of ethics, what we'd like to look at generally is whom is our duty owed to. And from the lawyer's perspective, they owe their overall duty to the client. They also owe a duty to the court. And when one looks at it from the perspective of the overall duty that is owed to the client, that duty that is owed to the client cannot be a greater duty than that is owed to the court. Because the court circumscribes the duties which are ethical for the lawyer to perform. And when a lawyer actually looks at it from the perspective of being counsel for the defendant in any matter, they have to stay within the ethical boundaries. They have a duty to do the best for the client, but they also have a duty to ensure that they stay within the ethical boundaries of the court. And in many ways, I think lawyers have to walk that fine line, but knowing what is right and what is wrong is actually circumscribed by the years of ethical decisions that have arisen in the profession. And I think lawyers are in a better position to realize and appreciate what is right and what is wrong based on that. And I think that's something that's important for lawyers to realize, and perhaps they should apprise themselves of their duty, not only to their client, but to the court as well.
Yeah, agreed. And so circling back to Dr. Stamper, what's his next move, do you think?
He has appealed against the prison sentence, and my understanding is, and I haven't independently checked this, that he's not currently in prison, that his sentence has been suspended pending appeal. So all eyes are on that. But I think in many ways, it's the lessons from this rather unfortunate episode rather than the fate of the individual that are important. And just picking up Nandakumar's point, it's interesting to contrast arbitration with litigation. One of the difficulties with arbitration, one of the reasons why it has a perceived legitimacy problem in some quarters, especially when we're dealing with these high-value claims against states. One of the reasons that there's no equivalent of the court. An arbitral tribunal is not a court. And we all understand that as lawyers, we owe a duty to our client and the court. So far as there's a conflict, our duty to the court prevails. Things aren't quite so clear-cut with an arbitral tribunal because it's essentially a private dispute resolution mechanism. And there's an interesting question, well, who does an arbitrator owe a duty towards? And there's a very interesting suggestion that an arbitrator may owe at least a soft duty to the arbitral community as a whole, not to do anything that undermines the legitimacy of the arbitral process. Because given that there are attacks on international arbitration in any event, some doubt in some quarters that it's an appropriate and acceptable way of resolving high-value disputes against states, one can see that arbitrators really need to be, if I can put it in simple terms, minding their P's and Q's when it comes to ensuring that the arbitral proceedings are run and seen to be run in a way that accords with the norms of proper decision making. And when arbitrators fall short of that standard, all they do is play into the hands of those states prefer to question the legitimacy of the arbitral process. I think it's very important that if arbitration is going to be used in investor-state cases or private law cases against state-owned bodies, it's absolutely critical that the arbitral process meets the highest standards of decision-making and the highest standards of professional ethics. Because if it doesn't, it's international arbitration as a whole that suffers.
Well, thank you for that. And to close off this conversation, I'll ask Nanda whether you've got any final comments or questions.
I think from the ethics perspective, we have to appreciate that there are many different ways of looking at it, depending on different communities, different legal systems. But there is an underlying community view that ethics actually relates to the duty that is owed to the people whom you are representing, one way or the other. And I think in many ways, that duty must be performed with the highest levels of honesty. And to some extent, ethics is connected to honesty. So I think we need to start looking at it from the perspective of whether honesty is being observed in the actions that are being conducted by most people, whether you are doing it in a capacity of an arbitrator, or whether you're doing it as a capacity of a director, or whether you're performing your duties in any other capacity of a manager within an organization. And I think that's important for us to look at.
Thank you. Gordon, any last words?
It's really just this. Arbitrator immunity from suit and prosecution is very important, but it's never unqualified. Under the LCIA rules, an arbitrator's immunity doesn't extend to deliberate misconduct. Same under the English Arbitration Act 1996, same under the Singapore and International Arbitration Act. Arbitrator immunity is always qualified, and it doesn't extend to bad faith. Again, I don't make any suggestion that this arbitrator or these claimants were acting in bad faith. But what it comes back to is this: it's the importance of an arbitrator making it demonstrably clear that they are acting in good faith, and where they suspect that all is not as it seems to be, the factual legal case that's presented to them, they're under a duty to investigate. It's not difficult to discharge those duties. They're quite simple to discharge, but they're very important to discharge. And it goes to the protection of the arbitrator, him or herself, against that corner of the field where criminal action becomes a possibility and civil liability escapes from the usual immunity rule.
Gordon, I think one of the things that's happening is that there is litigation funding that is being provided and permissible under arbitration proceedings which are being conducted in Singapore as well. There are obviously some ethical issues which may arise from the funding that is being provided for the arbitration to be conducted. And if any of the parties are receiving the funding, the questions as to whether there is an ethical issue that is going to arise from that has come up. What are your views on that?
Thanks. I know there are a number of jurisdictions, and I believe Singapore is one of them, where funding is allowed in arbitration but not litigation. And that means that practitioners in the area don't have the advantage of understanding the ethical implications and procedural implications of funding from their litigation experience. And it's the arbitral process that's really the guinea pig for testing these issues. And there are a number of procedural problems. One is the question of security for costs, for example, in arbitration. Should security for costs routinely be ordered against a funded party? That's less an ethical question than a practical question arising out of protection of parties. But there are some ethical questions, and one is ensuring that the funder is not improperly manipulating the proceedings. And in the early days of litigation funding in the UK jurisdiction, for example, this was a real fear. And the answer was that the funding community itself developed a system of self-regulation, developed codes of conduct to ensure that there was proper insulation of the funder from the day-to-day decision-making of the lawyers. Now, with arbitration, it's more difficult because, generally speaking, arbitration is a less regulated process than litigation. It's not integrated into the state machinery in quite the same way. And that means that a heavy burden of responsibility is placed on arbitral institutions, and in the case of ad hoc arbitrations, on arbitrators themselves. And it seems to me that, although you can't state this in overgeneral terms, arbitrators do have to keep a weather eye in funded cases for what the funder is doing. And if they feel there isn't sufficient insulation between the funders and the parties who are bringing the case, then they need to think about what steps are open to them to take to deal with that. I mean, generally speaking, I think litigation funding and arbitration funding has been very helpful. Speaking as arbitration counsel, it's been a game changer. It has enabled claims to be brought where justice demands it, which in the absence of funding, claimants wouldn't have been able to bring, particularly where you've got a well-funded commercial respondent or indeed a state and legitimate damages claims. Funding has enabled cases to be brought, which deserve to be brought, which previously haven't been brought. But the other side of the coin is that arbitrators do need to be aware. One of the suggestions that was made of the conduct of the Sulu litigation is that the individual claimants, they're Filipino nationals, who don't have their own genuine commercial interest in the case. And the suggestion has been that effectively they've been hoovered up by the funder and they've been used as proxies to run the case on behalf of the funder. Now, again, I make clear I don't make any comment on whether that complaint is well founded or not. But it's the kind of thing which, once the suggestion is made, the arbitrator really is under a duty to investigate and think about and consider what procedural steps might be taken to ensure that the parties before him or her are really the parties controlling the case and taking the decisions in the case about what points should be made, which points shouldn't be made, and how the evidence should be presented. That's the function of the parties and the parties' legal representatives, not the function of the funder. So that kind of editorial control over the management of the case, that's a red flag area in arbitration. as I say, because these are early days, arbitration funding is relatively new compared to litigation funding in other jurisdictions. In jurisdictions where arbitration is the guinea pig, perhaps it's an unfair burden to place on arbitrators. But I think there needs to develop fairly swiftly some learning as to how you identify cases where funding may be causing an ethical problem in the arbitration and developing techniques for managing.
Gordon and Nanda, thank you very much for joining us in today's conversation.